colleagues. Good morning. It's the appointed time. We have a quorum. I call to order the meeting of the Bills Committee. At the last meeting, actually, let's first invite representatives of the administration to come inside the conference room. At the last meeting, members requested that the administration provide supplementary information. The administration has provided a written response. It is now numbered as CB brackets 3 746 2025 brackets 01. It has been forwarded to members. I will first ask the Education Bureau representative brief members on the paper. Thank you, Chair. I'll be brief. Regarding the promulgation of administrative guidelines, we have discussed this issue on multiple occasions. On this occasion, we are asked whether we need a legislative framework for promulgation of administrative guidelines. We consider unnecessary. It is our existing policy that we can promulgate administrative guidelines as necessary. As for offense relating to the failure to comply with teach-out requirements on colleges, again, we discussed this on multiple occasions. Last time, members raised concern in particular on the role of the members of boards of governors. And we were talking about a particular unlikely scenario as raised by the member. We consider that members of boards of governors will act in accordance with their posts and protect the interests of students, but there will be defenses available should the circumstances warrant so. As for appeal mechanism for registration-related matters, the Chief Executive and Council may appoint a tribunal, and a member raised concern on the coverage of do or other things that are necessary for a proper inquiry by the tribunal. The member thought this to be too much power. And we would say this: it is necessary to confer sufficient power on the tribunal to flexibly decide to do all things that are necessary. Another member also asked us to provide some flowcharts on the procedures for making an appeal. We have provided those in the annex to the response. On requirements on submission of strategic plans and annual reports, colleges must prepare and submit to the permanent secretary a strategic plan at least once every 5 academic years. And each strategic plan must contain the academic development plan, etc., for at least 3 academic years in the future. And colleges must also arrange for its board of governors to review the strategic plan applicable to that academic year in every academic year, and make available to the public an abstract of the strategic plan applicable to that academic year. We believe this arrangement provides sufficient flexibility for colleges to adopt a strategic planning cycle ranging from 3 to 5 years. Colleges may also amend and submit an updated strategic plan. This should offer some convenience to colleges. Also, the strategic plan submitted by colleges before the proposed new Regulation 8A comes into operation or when applying for registration, they are also accepted as the first strategic plan submitted in accordance with the amended ordinance. As for annual reports, the annual reports must be submitted within a certain deadline, that is within 30 days beginning on which an annual report is made. Colleges must make available to the public in the form specified by the Permanent Secretary an abstract of the 5 latest annual reports as well. As for a member's concern on whether the EDB would provide a grace period for colleges that fail to submit strategic plans and annual reports, we consider our existing arrangement has given ample opportunities for colleges to make amends if necessary, so there is no need for amendment. That is our stance. We will also promulgate some practical guidelines through administrative measures so that colleges will be well aware of the relevant statutory requirements. We will also maintain liaison with colleges to provide assistance as and when necessary. So that's our response to the issues raised at the last meeting. I would also like to go into the committee stage amendments. Well, actually, for the draft committee stage amendments, they are tabled before members, CB brackets 3746/2025 brackets 02. Why don't we complete clause-by-clause examination first before we discuss the proposed committee stage amendments? Sure. All right. Now, at the last meeting, we completed scrutiny of clauses 13 to 30. We'll start from clause 31 today. Will you start the clause-by-clause examination? Thank you. We will make use of the Chinese marked up copy, page 67, page 58. Chair, excuse me. We actually talked about from pages 58 all the way through to pages 66. The forms have been deleted. So we have dealt with this on the last occasion. So I would like to draw members' attention to page 67 of the Chinese marked up copy. These are related amendments because we have made amendments to Chapter 320. Let me first ask members if they have any questions on the deleted forms. None? All right, please proceed. Thank you. We have some related amendments that are mostly technical amendments in response to the amendments made to Chapter 320, mainly of some references. Pages 68 to 74, there are no amendments at all. All right, now page 75 of the Chinese marked up copy. We added a definition for sub-degree in section 3. We should also refer to page 76 of the Chinese marked up copy as well. We have added subsection 1A to section 18A to say an approval in relation to the provision of a post-secondary education through a program at the sub-degree level at a school expires after 2 years beginning on the date on which section 34 of the amended post-secondary colleges ordinance coming into operation. Excuse me. Let me first ask if members have any questions. Please proceed. Excuse me. Professor Chow has questions. Thank you. I have a question for the Deputy Secretary. Basically, what it means that for those under operating sub-degrees under Chapter 279, they would need to act in accordance with the amended Chapter 320 later, right? Right. I also want to ask about the list of outstanding items for discussion. It is said that we have to have the relevant colleges provide strategic plans and annual reports. And colleges must prepare and submit to the Permanent Secretary a strategic plan at least once every 5 academic years. And you're saying that you only need them to provide content for at least 3 academic years. So would it cause a loophole that 2 academic years would be missed in the 5 academic years? Well, I would say this: they must provide at least once, so it can be more than once. They must cover content for every year in the end. Well, I think it's confusing because with your wording, you only say the college must submit a strategic plan at least once every 5 academic years, but then the contents contained would be for at least 3 academic years in the future. So would colleges be able to omit something at some point? Well, I would say this: these are the requirements that are set out in the provisions. When we say each strategic plan must contain the academic development plan, expected goals, and performance targets for at least 3 academic years in the future, and colleges must prepare and submit to the permanent secretary a strategic plan at least once every 5 academic years. But if colleges only submit a strategic plan once for 5 academic years, and they have a strategic plan that covers only 3 years of contents, in the 4th year they must submit another strategic plan. We are wording things this way to offer colleges some flexibility, because the colleges may have different cycles. Well, I think people, when they see the text, they may interpret differently, because there are the 2 different figures. If they do not submit another plan to you, it may cause a loophole, or it may constitute a trap. Would you consider amending the wording, Mr. Regarding paragraph 11 in our response, we believe our requirements are very clear. Colleges must prepare and submit a strategic plan at least once every 5 academic years, and each strategic plan must contain the academic development plan, etc., for at least 3 academic years in the future, and each academic year must be covered by a strategic plan. But we understand college personnel may not read the law, so we will promulgate administrative guidelines to ensure college personnel understand the requirements. Well, I would say this: it is possible for you to amend the wording to avoid any confusion. Exactly, we shouldn't have anyone possibly misunderstanding the provisions. I think the Education Bureau officers may know the requirements really well, but for general personnel, it may be confusing. Well, we would ensure through administrative guidelines there will not be any confusion. Thank you. Thank you. We are now on page 77 of the Chinese marked up copy for section 86, prohibition of issue of degrees or documents resembling degrees. This also relates to a member's concern raised earlier, which we addressed. For the institutions that are operating sub-degree programs at the moment, they will be migrated to Chapter 320 in due course, which is why we'll be removing the relevant provisions, relevant parts from the Education Ordinance. Thank you. Please proceed. Page 78 of the Chinese mocked-up copy, we have added a section 101 after section 100. These are some transitional provisions. We also have some offense-related provisions and defenses. In particular, for subsections 7 and 8, if the management authority of a school is required by a notice to continue to provide the post-secondary program, the management authority must not, by doing so in compliance with the notice, be regarded as having contravened Section 18A. And in subsection 9, it says in particular what the transitional period means. All right, please pause here, Professor Chairman Kong.
Chairman, my understanding is that there are 7 colleges registered under CAPS 279 that will suspend or stop the post-secondary courses. So after the amendment, would they have to go through the VQ again, Chairman? Now, there are some self-financing arms of the 8 UGC fund universities, as well as the 279 colleges. We will be liaising with them to help them migrate to CAP 330. In terms of the VQ, we'll have to look at the track record to make sure that we'll streamline the arrangement. And the self-financing arms of the UGC fund colleges will be treated in the same way. We have been liaising with the colleges over the years, and with passage of the bill, we will be meeting with them to look at the situation individually. And different colleges will have different objectives. Some of them would like to be private universities, and we will have to discuss with them to see how they can achieve the purpose in the most efficient way. Mr. Tang Fei, I go along with that, Chairman, that the transitional arrangement is really a vague term because different colleges would differ, and some colleges are saying that they are concerned about the rent. They run these sub-degree courses under 279. So when they migrate to CAP 330, they will have to change in terms of the rental arrangement. So they hope that the government departments would help them with the tenancy agreement in the transitional period. Now, if you merge everything, it would be easier. Things that can be handled by the department, one single department, would be easier. Thank you. Chairman, I'm sure this was raised before, and I said in response that for individual colleges, if there are any changes to the tenancy agreement, we will render assistance, and we will do so in collaboration with the lands department. And the lease would be amended. Now, when migrating from 279 to 330, this is in line with the government intention. We will render assistance as much as possible. Ms. Carmen Khan? Chairman, thank you. Mr. Tang talked about the lease arrangement, and in the transitional period, maybe some of them will be stopped, and the secretary said that they will be liaising with the relevant party together with HKCAAVQ, and maybe they have different considerations, and the accommodation is one of the considerations there. According to your understanding, what other factors are at play here? That's first question. Second, with passage of the bill, there will be 2 years of transitional period. How can LegCo continue monitoring this area of work? Permanent Secretary. The colleges are concerned about the liaison with the HKCA AVQ and whether there are any speedy ways to migrate to CAP 330. Now, the CAVQ has given the undertaking that they will provide an efficient accreditation for migration purposes. At the first meeting, the Secretary already emphasized that whatever we do, we prioritize quality. We have to make sure that the courses will be commensurate with good quality. The land lease is one of them. Now, they're also concerned that the appointment of members of the BOG, the president, the teachers, the registration, these would be dear to their heart. They are also concerned about the deregistration procedures. Because these are the areas that they have to pay attention to. We do hold briefings to make sure that we will be able to get a message across, and also to handle whatever queries that they have. As I said, there will be practical guidelines to be promulgated, and there will be liaison to make sure that they are in the picture. The tripartite meetings mean that depending on the unique circumstances of the colleges, we will address their requests individually. As to the oversight of LegCo, we can do so through the education panel. With the passage of the bill, it would take us until the 1st of August next year for this to be implemented. The majority would go into effect on the 1st of August next year. For others, there will be a 2-year transitional period. I'm sure members are really concerned about this. The Education Bureau would be only too delighted to bring members up to speed at the education panel at the right time regarding the progress and also the areas they would like to highlight for members' attention. Ms. Khan, Chairman, well, you have to look at the supply and demand in terms of the courses. That will be the decision of the colleges. Would there be any arrangement for grandfathering before the passage of the bill? Those courses that are already in existence would be able to bridge over. Well, there will be no grandfathering arrangement, but as I said a moment ago, the first hurdle is to go through the CAVQ. If the colleges would like to discontinue certain courses, and after migration to CAP 330, they like to change the positioning, that's another matter altogether. But basically, they can migrate to CAP 330 wholesale, or unless they want to take this opportunity to change their policy and discontinue with certain courses. But that's entirely the prerogative of the colleges. Ms. Khan, whatever the situation is, before courses exist before 1st of August 2026, we'll be able to bridge over. Is that right? No, that's not the case. They have to go through the accreditation of the HKCAA VQ. But they will have to have regard to the performance of the courses, and the CAA VQ will be making the recommendation for them to be migrating. What they will have to fulfill the requirements before they will be able to go through. That's right. Please. Let's move on to 0080. That's specification of public officers' notice. There's the power conferred upon the secretary and the permanent secretary, and these are the consequential amendments. 0081, that's amendment to public order ordinance regarding the reference to the colleges. 0082, A3, no amendments there. 0084 is subsidiary legislation A. the reference to the college as defined in the bill. 086 education exemption private school offering non-formal curriculum order, cap 279 subleg F 0088889 1991, 92, 93, 94, 95, 96, 97. No amendments there. 0098 is in connection with the road traffic ordinance. That's in relation to reference to colleges as amended. 0102, 0103, 0104, 0105, 6, 7. No amendment there. And 0108 is in relation to amendments to sex discrimination ordinance, cap 480. That's in relation to reference to colleges and also the council. 0111, 0112, no specific amendments. 0113, amendment to the family status ordinance, that's in relation to the reference to the college as defined in section 2 and the council. 0114, 15, no amendment. 0116, that's amendment to copyright ordinance. That's reference to college as defined in section 2. 0117, 0118, 19. There's amendment to Legislative Council Ordinance Cap 542, reference to colleges as defined. 0122, that's the C election. And 0113, race discrimination ordinance, that's in relation to the reference to college and also the council. 0125, 0126, no amendment. 0127, amendment to the minimum wage ordinance. That's in relation to the reference to college. So much for the scrutiny of the Chinese version of the marked up copy. All right, we're done with the scrutiny of the clauses of the Chinese version. Legal advisor, any comments on the English version? Chairman, thank you. Well, earlier we wrote to the administration about issues raised. Other than that, we have not picked up anything regarding drafting of the bill. Any comments? All right, moving on now. As I said, we should wait until we're done with the clause-by-clause scrutiny before we look at the CSAs. Would the Deputy Secretary please take us through the CSAs, please? Chairman, please refer to paper Post-Secondary College Amendment Bill 2025, proposed CSA 9 to 11, that's in Annex 1. This is in response to the Assistant Legal Advisor's views. We proposed new sections 4A8 and 5A7 to make sure that after refusal to approve the application for registration of BOG member, president, vice president, teacher, the permanent secretary will, as soon as reasonably practicable, by way of written notice, inform the relevant applicant of the refusal and reasons for the refusal, with a view to aligning the time limit of issuing the written notice under other provisions. All the details are set out in Annex 1. Any comments?
Please proceed. Thank you. Part 2, Item 2 is the catch-all provision. We have made reference to the Protection of Critical Infrastructure's Computer Systems Ordinance Section 69, introducing a provision into the bill to empower the Secretary to give directions. We will add a proposed new Section 13A to Chapter 320 to empower the Secretary to give directions to the Permanent Secretary or an authorized person with respect to the performance of a function under Chapter 320, and a person to whom a direction is given must, in performing the function, comply with that direction. The details are set out in Annex 2. Any questions from members? If not, please proceed. Thank you. Item 3 is about the commencement date. We will amend clauses 1, 2, and other related provisions to say the commencement date will be 1st of August 2026, save for clauses relating to the delegation authority to approve the award of degrees, which will come into operation on 1st of August 2025. The relevant provisions are set out in Annex 3. Any questions from members? None? All right, legal advisor, any comments? Chair, excuse me. Only earlier today we have received the documents. We will scrutinize the relevant documents. When we have any comments, we will update members as soon as possible. All right, thank you. So that's it for the examination of the bill, and the administration has proposed some committee stage amendments. I would like to ask members if you would like to propose any amendments. If after the meeting you decide to propose amendments, the deadline is 23rd of May, next Friday, before 5. You should submit before that time your draft amendments to the Secretariat. The Secretariat will forward the proposed amendments, if any, to the administration for the provision of a written response. The Secretariat will also ask members, should that be the case, if another meeting has to be held. If another meeting has to be held, we will fix another date for the meeting. The Secretariat will also work with the administration to see when second reading debate will be resumed. That should be decided after next Friday, and later on members will be notified. All right. Would members wish to propose any other business? Yes, Ms. Common Khan. Chair, as the legal advisor said, the proposed committee stage amendments were only submitted earlier today. I note that mainly there is the catch-all provision to be introduced. And we also have now a specific date for the commencement date of certain provisions to be 1st of August 2026. So the grace period will be 2 years. They have made it clear now when the provisions will come into operation with the specific date. What are their justifications for providing a specific date? Deputy Secretary. All along, we did say approximately 1 year afterwards, the provisions will come into operation based on the discussions of the Bills Committee. We believe with the progress of the Bills Committee, we should have the provisions come into operation at least in June of next year, and we consider it probably more appropriate to designate a specific date to be 1st of August 2026 for the provisions to come into operation. And with a specific date, it would be easier for colleges to make plans. If we do not say a specific date now, we need to promulgate a commencement notice. We also need to perhaps decide on the dates later. I think with this, it would provide more certainty to colleges, which is ideal. I do note that this is before also the beginning of the academic year, otherwise there may be some delay. Alright, any other questions from members? If not, we have completed scrutiny of the bill. If another meeting has to be held, we will discuss with members and the administration on when the next meeting is to take place. I thank members and representatives from the administration for taking part in the deliberations of the Bills Committee. Meeting adjourned. Thank you.